petition. We have a request to rezone from R2 Single Family Residential to B2 General Business. The matter was published in the Daily Herald on November 30, 2022. We have either no comments or general remarks from various departments of the county. Objections to the petition have been filed by the City of West Chicago and the Village of Winfield. Let me say this as an initial matter. Any testimony whatsoever about what the proposed use will be is of zero value, because this is a request for a rezoning. If we grant a rezoning request, there is an unlimited opportunity to do anything that's required or permitted within the B2 district. Our practice has been, wherever possible, convert the rezoning request to a conditional use for a PUD where we can impose conditions about the use, hours of operations, and whatever else. Secondly, the objection from the City of West Chicago indicates that there's a pre-annexation agreement which should prohibit us from moving forward with this case until that's resolved. So my inclination is to set this matter over till January 5th, which is our regular recommendation meeting, to hold a status report only, not conduct a public hearing on the case, but simply hold a status report to determine what the petitioner wants to do and what the state's attorney advises us we are permitted to do, given the pre-annexation agreement and the objections from the Village of West Chicago. And with that, I won't ask for a motion to that effect now, but I'll recognize the petitioner's attorney.
Thank you. Good evening, everyone. Chairman Carthol, members of the ZBA, my name is Mark Daniel. I represent the applicant in this case. I reviewed Mary Dixon's correspondence on behalf of the City of West Chicago. I attempted to reach her today. Apparently she was in court, not available. I don't know if anyone from West Chicago is here tonight. I've reviewed the annexation agreement. When you work back on a matter like this, you go to the trust and you retrieve the letter of direction where the property's beneficial owner directs the trust to sign a document. We did that. We reviewed that document. We reviewed 3 documents that are in the folders in front of you. The annexation agreement was recorded in not one form, but 3 different forms with 2 different effective dates and different exhibits. Setting all that aside, there are provisions in the annexation agreement that essentially say that West Chicago had entered into a pre-annexation agreement with the owners. It was originally over 50 acres and it eventually boiled down to 30 some odd acres. And West Chicago would take the property within its corporate limits according to what the county of DuPage had issued building permits for. If a building permit was issued, West Chicago would conclude the permitting process and allow the use to continue. All right, note that I addressed it in a letter today to each of you. I provided the annexation agreements. Article 7, Section 11 specifically says we'll accept the uses in as they are, including all the non-conforming lots that don't meet the acreage requirement or the width requirement or the depth requirement, the non-conforming homes that don't meet the yard requirement, and the uses that don't comply with our ordinance. We'll accept those as they are. And as to things that don't exist yet, but they have a building permit from DuPage County, we're going to take those in too, and we will issue a certificate of zoning compliance for those uses. That's what the annexation agreement says. There's nothing in the agreement that says the property has to remain residential in use. It doesn't say it anywhere, not in any of the 150 pages recorded across 3 different years. So there's no requirement for residential use here. To the extent that we're dealing with the City of West Chicago and that volley of communication, we would ask that you continue to hold the hearing tonight I've been involved in cases where the zoning board of appeals has indications from the forest preserve. I had a property that was up before you for an R1 to, I think it was an I2, down by 55. And in that case, the zoning board continued because whether or not the forest preserve was interested in acquiring the property didn't matter to the decision at hand. The same is true of other cases that have been at issue involving annexation agreements or a municipality's intent to annex. The same is true of cases where someone's condemning land for highway purposes. You have a job to review the facts before you. And I'm asking that you do that tonight. Nothing that you do here will prevent the city of West Chicago from annexing the property. Nothing. It just leaves a question to the city of West Chicago. It's not even a county question. It leaves a question to the city of West Chicago. Are we going to annex? And once we do annex, we're going to comply with that agreement. West Chicago never said we are going to annex the property.
But, I'm not the attorney for the county. We sit here as a board to evaluate petitions that come before us that are appropriately before us. There's an allegation that this is not appropriately before us. In addition, there is the first matter that I raised that I don't care what you say tonight or at any subsequent hearing. I'm not going to vote to do a blanket rezoning of residential property to B2 unless we can put conditions on it. You certainly know that we've requested that these be restructured as conditional use for PUDs so that we can put condition rather than blanket rezoning. So
This
if
use
this
is actually
board-
allowed in West Chicago in the ER2
I'm
district.
not
as
going
a
to argue
PUD.
with you because I can't evaluate your arguments without the other side. And
They should be here, Chair.
if West Chicago were here, I would not make that legal decision for the county. So
Can we proceed with the hearing and leave it open to the
Absolutely
next?
not in my opinion. If the rest of the board says yes, I have proposed a course of action, which I don't understand how that prejudices you, because this matter would not, if we held a whole hearing and conducted a vote tonight, which is not our practice, we defer to a recommendation meeting. I don't think it would move this matter forward significantly at all. To table this for a status report on January 5th does not prejudice this case. This is a very significant case.
It is an important case to everybody, and I'm not
Okay.
trying to rush, but we want to be sure that we're going forward with the hearing, that the hearing is opened and continued to January 5th. We don't want to have a
No, the
status.
hearing is not open and continue. A status is.
But then you have to renotice, and that puts us off until
No, you don't.
February.
No, you don't. If we continue the matter to a date certain for the purpose of status only, you don't have to republish. If you did have to republish, so what?
The license expires.
There's a delay, and we lose property rights.
There's a time.
Then extend it with your, whoever you are, contract purchaser or whatever.
When the applicant has done everything right, and the city's not here, Mr. Chairman, the best thing to do is to
Yeah,
proceed and keep
okay.
it open.
If I let you bring your case tonight with a B2 without converting to conditional use for PUD, you are highly likely to get, because of the practice of the board, that we cannot and do not impose any conditions on a rezoning. You're likely to get a no vote. So if that's what you want, we'll vote the matter tonight. But no, I take that back. I was being a bit sarcastic. I've proposed an alternative. I'd like, if the rest of the board does not concur with that, then fine, but I'd like some consideration of the deferring this case for status only to our January 5th recommendation.
We will lose property rights under the license.
Well, then sue the county. I'm not going to make a decision.
This is a matter of having everything done correctly and having the party interposing the objection under an inapplicable annexation agreement that doesn't say
You're,
they have
we've got two
jurisdiction.
issues here.
They don't say they have jurisdiction. They say that if you vote this way and we proceed, it might be a breach of the agreement. They don't say you don't have jurisdiction.
Okay, well, I'm not gonna make that interpretation as a lawyer for I'm not gonna make a legal determination for the county. I'm gonna request the state's attorney to make the legal determination.
You
And
have
once
the year
again,
running in July. The license will.
Well, I
run-
concur with you. I'd like to just put forth the motion that it be continued to the date certain of January 5th for a status. I concur also with your idea with that we don't just grant a variance that runs with the land, they could do anything. It should be a PUD, so we could put some restrictions on it. So for that reason, I move to table it until January 5th, at which time there'll be status. I'd also request that staff make West Chicago and any other interested party, tell them that they probably want to appear for the status. And I'd also ask that the state's attorney weigh in on what their opinion is.
This is the opposite about what's supposed to happen with lead certified projects.
okay, well,
It's the
then we're
opposite.
wrong,
It's
but
supposed to be on a
we're
track
entitled to
and
be
not
wrong.
delayed.
Okay,
It's
so
a
there's a motion on the
important mistake.
floor. Is there a second to that motion?
Second.
Motion by Mr. Cutter, second by Mr. Moran. Is there any discussion on the motion? Well, I think we should have a roll call vote, Paul, so we can call the roll.
Mr. Ketter,
Aye.
Mr. Moran,
Aye.
Mr. Murphy. Ms. Anderson.
Aye.
Aye. Sorry. Sorry.
Was that Zane indicating aye?
Aye. And then. Aye. So 7 ayes, 0 nays.
Well, I didn't vote yet.
Oh, Mr. Carter.
I'll
sorry.
vote aye. Okay, I'm sorry, folks, but I want to do this pretty carefully to the petitioner. You know our position on either one of these issues. Either the conditional use for the PUD so that we can create conditions, or whether we're permitted to proceed at all. You need to report to us on January 5th as to how you intend to proceed. But again, we're not going to hold a public hearing on that date. We'll find out what's going on, whether they're going to restructure this petition, as I indicated, and then set the matter for a date, probably a week or so out from that. There won't be an additional publication because we're going to continue this matter to date certain time after time as we need to. So
Mr. Chairman, may I just comment on your inquiry on restructuring the petition? There's no conditional use option for this at this point in time. We would have to invent something.
then fine,
So
then
we
then you
won't
get
be
the state's
amending
attorney to tell
seeking
us.
a conditional use. Well, your code says that. This is a permitted use in the B2 district.
You need to confer with our staff about that.
You understand the code, Mr. Chairman. Now, on the issue of the planned development, we have a single parcel that's 5 acres, and we're proposing to construct one building. It doesn't need a planned unit development. And to say we're not having a hearing because you won't condition your relief.
We never condition relief for rezoning.
Exactly. But it is a permitted use. It shouldn't need to be conditioned. IDOT, all the licensing and permitting, that's all in place.
Mark, if you want to proceed, you tell us on January 5th, I refuse to consider any alternative. I'm going forward with a rezoning request. And if that's how you want to proceed, on January 5th, we will set the matter for a hearing on rezoning.
Can we set it for a hearing tonight? We don't
No,
want to
I
have the
can't.
delay, Mr. Chairman.
No.
We are not going to be able to come in.
I'm
for a
not going to
conditional
set it
use
for,
or a planned
I'm not going to take any action on this, any substantive action on this until I hear from the state's attorney concerning the West Chicago position regarding reannexation. How are you prejudiced if we set this today or January 5th?
Because you're not even starting the hearing January 5th.
That's right.
All right, you will set a status date, and then we'll come back when. And then we'll have this issue with the lag time to the county board, and it's March. And then we have to get building permits, and the
I know
building
it's a
schedules off with a
complicated process.
license from the state of Illinois that is worth a lot of money. It does not make sense to continue. You could keep it open.
Well,
There is a license,
It's a
an
7 to
active
0
license.
vote to table it to January 5th. I'm not going to debate it any further. I'm sorry that we're not proceeding tonight,
It's unfortunate.
but we're.
Our folks